Good morning and thank you for joining us. Welcome to Ecuador's Intracampos Oil Bidding Round webinar. For our oil and gas team at Pérez Bustamante y Ponce, it is a pleasure to have you join us for this webinar where we will be analyzing the legal and tax environment of the Intracampos bidding route. Please feel free to ask any questions during the presentation as we will be answering them at the end of the presentation. Today we're joined by the following speakers. Mr. Francisco Roldán, he's the coordinator of the Energy Department at Pérez Bustamante y Ponce and one of the most experienced lawyers in the oil and gas industry in Ecuador. Also joining me, María Rosa Guerra. She's the co-leader of PBP's tax unit and an expert in the tax and finance of the oil and gas sector. And finally, myself, Patricio Albuja. I'm part of the energy team with a focus in oil and gas and with considerable experience in Houston and a licensed attorney in Texas. Welcome again to this webinar, and we will start now with Mr. Francisco Roldán. Francisco.
Thank you, Patricio. Welcome to everyone who is attending this webinar. For us, PBP, is a pleasure that you join us in this webinar. The government of Ecuador announced the Intracampos oil fields bidding round. The government has offered 8 oil fields in the Amazon region of Ecuador, which seem, according to the technical information that have been provided by the government, seem to be very attractive for the oil companies. The blocks offered are Charapa, Chanangue, Iguana, Perico, Sajino, Arazá, Espejo, and Pañayacu Norte. Sorry for the names of the blocks, but they are baptized with that names due to the location in the Amazon region. The government has announced that the modality of the contract that will be used in these Intracampos or fields is the production sharing agreement. In Spanish is known as Contrato de Participación. The main characteristics of these production sharing contracts are the following. The parties of the contract are the Ecuadorian state and the contractor. The Ecuadorian state will be represented by the Ministry of Hydrocarbons, and the contractor may be one company or a consortium of companies. The production is shared between the contractor and the state in the percentages offered by the contractor, negotiated with the government and established in the contract. Each party is entitled to market its production share. The production will be variable, subject to international oil prices and production volumes. The exact formulas and methods have been provided in the contract basis and are also developed in the model contract that has been circulated by the government. With the income received by the contractor as per its production share, the contractor has the obligation to cover all type of expenditures, such as CAPEX and OPEX. And also, those expenditures will include marketing and transportation costs. The payment may be in kind or cash. Most of the companies in the past have agreed with the government to take their participation in kind, but also cash payments is possible according to the rules that govern these Intracampos oil fields. If the participation is in cash, it must be multiplied by the reference price and less transportation costs, marketing costs, the Amazon tax, Law 40, and other applicable taxes that will be explained later in this presentation. The contract has two periods, the exploration period and the exploitation period. The exploration period lasts 4 years, where contractor must comply with a minimum exploratory plan that must be submitted by contractor and it must be included in the contract as an exhibit. The exploration period may be extended for 2 more years if the contractor submits to the government an additional exploration plan that must be complied during this extension. The exploitation period begins with the approval of the development plan. In this scenario, contractor has to submit the evidence of markability of the oil reservoirs found in the block. The exploitation period lasts 20 years and may be extended as agreed by the parties. The model contract and the contract basis also foresee that contractor has to submit 3 types of guarantees. The first one is a parent company guarantee, which is not a monetary guarantee. It's only a document issued by the parent company that guarantees the performance of the contract by the subsidiary or by the branch. The second guarantee is the exploration period guarantee, which is required for the exploration period and that must be submitted by the contractor when executing the contract. That guarantee has to be issued and is equivalent to, must be either a bank guarantee or an insurance policies, sorry. And the guarantee must be equivalent to 20% of the minimum exploration plan offered by the contractor. The exploitation period guarantee is also a monetary guarantee required for the exploitation period. That guarantee, again, may be a bank guarantee issued by a bank established in Ecuador or an insurance policy, and that is equivalent to 20% of the committed activities that must be performed by the contractor during the first 3 years of the exploitation period. Regarding the environment, contractor must prepare an environmental impact plan and must obtain an environmental license prior to starting the exploration activities. The same type of environmental impact plan and the environmental license are also required for exploitation activities. Here it is important that you know that during the bidding process there is a period for questions and answers, and it will be advisable that the companies that participate in this bidding process ask the Ministry of Hydrocarbons the possibility of not computing within the exploration period the time that takes the authorization and approval of the environmental plan and the environmental license. Due to new rules approved by the National Assembly and the government, it is important that you all know these norms that are applicable for employment and preferential rights of the local industry. Regarding the right to preferential employment, you should consider that no less than 70% of contractors' employees must be Amazon residents. The exception, obviously, is if that personnel does not have skilled capabilities. The contractor must increase progressively the employment of individuals from peoples and nationalities up to a minimum of 10% of the total role employment. In respect to the preference to national industry, there is an obligation of contractor that should prefer or must prefer the national industry for purchases of assets and equipment. And there is a rule that says that if the national companies or national industry offers a price that is 15% higher or over the competitors, that national company has preference to be awarded the contract. Regarding the rules to solve controversies between the state and the contractor, the legal framework applicable in Ecuador establishes that arbitration is mandatory for the solution of controversies in Ecuador. In this respect, there are two types of arbitration procedures. The first one, which is for controversies of less than $10 million, in which case the arbitration must take place in Quito and administered by the Chamber of Commerce of Quito, that has a very reputable arbitration center. For controversies over $10 million, the legal framework establishes that must be administered by the Permanent Court of Arbitration at The Hague. The rules applicable are uncitral, and the venue for arbitration is Colombia. In both cases, the applicable law is the Ecuadorian law. Our legislation also foresees the possibility of executing investment agreements. The purpose of these agreements is to guarantee the stability of rules regarding calculation of the tax base and income tax value. The stability may be negotiated in respect of currency remittance tax, which is 5%, and that will be explained by my colleague lately. The possibility of to import goods required for this project without incurring in this CRT. If the contractor chooses to execute the investment agreements, the solution of controversies is quite similar to the former description, with the possibility of going to the arbitration court at The Hague and uncitral rules applicable, or go to the International Chamber of Commerce in Paris and the rules of that of the International Court of Arbitration, and also the possibility of going to the Inter-American Commercial Arbitration Commission. To accomplish or to have access to these investment agreements, the investor has to invest at least $100 million, and a technical report from the Ministry of Energy evidencing the economic benefits of the country is required. I'm passing the floor to my colleague, María Rosa Guerra, who will explain to you the following section of this webinar presentation.
Hello, we are going to be explaining two main points of the participation of production sharing contract, which is the contractor share formula and the sovereign adjustment. Regarding the contractor share formula, as you may see in the presentation considers, let's say, two main characteristics. One, which will be the X factor, which is an average factor that is expressed in percentage and correspond to the contractor's participation based on the formula that you can see here. And in this formula, there are two percentages which are applied to the contractor participation, which is the 1.5% and the 6%. These two percentages has been already determined by the Committee of Hydrocarbons, which means that these percentages cannot be modified. The other two amounts, let's say, that it will be important for you to take in consideration is L1 and L2, which it's have been determined also in 30,000 barrels per day and 60,000 barrels per day, which these will be affecting in the calculation when we are determining Q1 and Q2, and therefore in the average factor. PC will vary in terms of, the following chart that we will also be explaining to you. The PC, which is the participation contractor, has also to see the price of the crude oil, which is the $30 per barrel and $120 per barrel. When we have a price that it's equal or less than $30, the contractor share will be a maximum of 87.5%. However, when we have a price that is equal to or higher than 120, we have a participation for the contractor that it's minimum 40% and a maximum of 82.5%. This means that based on the price of the oil, this line will be moving based on what you will be negotiating with the state in the contract. The sovereign adjustment is another concept that it has been included in this production sharing contract. What it states is that when the state benefits are less than 50% of the contractor benefits, a formula will be applied to balance the state benefits, reaching at least to 50%. The sovereign adjustment will be applied during the next fiscal year, calculating state income and contractor income. What means this that will be applied during the next fiscal year? Meaning that the amount that has been determined as an adjustment has to be calculated as from April until December, because the idea is that the adjustment should be recuperated by the government in the production that will be, generating during the rest of the 9 months of the next fiscal year. Here is the formula that it's being considered for the calculation of the sovereign adjustment formula. As you can see, the formula considers initially what it was stated as the average factor expressed in percentage that corresponds to the contractor's participation. And then you have here an adjustment of the sovereign adjustment formula. This AS corresponds to the percentage that permits to balance the state benefits. And the calculation is determined in the contract basis. What are the state benefits? The state benefits has been stated as the income tax, the profit sharing attributable to the state, which is the 12%, payments received on account of the tax for sustained development of the Amazon region and the Law 40 and other taxes, or we can say that it mean the best word would be tributes applicable to the contract, because there are not going to be only taxes. There could be, for example, the contribution to the superintendency of companies. There could be also the ISD. However, in the contract, neither in the contract, neither in the contract basis has been established really in detail what other tributes or should be applicable as part of the state benefits. Then the contractor benefits. The contractual benefits are the net current cash flows of the year. How that should be calculated. The net current cash flows will mean that it's the net profit less the investments plus the amortization and depreciation. The amount of the net profit should be obtained from the reports of the auditors, the independent auditors for the calculation. And once the contractor benefit is adjusted, the initial participation formula will be applied, which means that, as you can see, the X factor, this average factor, will stay the same, only without this adjustment of the sovereign adjustment formula. Okay, so now I will be passing to Patricio to start for the Intracampos instructions for registration and qualification.
Thank you, María Rosa. The government, the Hydrocarbon Ministry, have issued several documents in order to set the rules for the registration and qualification of companies to participate in the Intracampos bidding round and finally file an offer. And this is a summary of the main points and the main requirements that these guidelines provide for national and international companies. We have to understand that there are two main parts before submitting an offer, which is the registration process and the qualification process. The first part, the registration, in regard to the companies who can be registered, mentions that it could be national or international companies, private or public, parent companies, subsidiaries or branches. In respect of subsidiary of branches, these companies may use the information and the guarantees from their parent companies in order to file their information on their behalf. It is also important to mention that only if a contract is awarded, then there's the obligation for these international companies to set an SPV, and a special purpose vehicle in Ecuador. It could be either an Ecuadorian company or a subsidiary in Ecuador. There's no need to submit an SPV before the award of a contract. Following the registration process, this is the process on how to register. First, there's an online registration on the webpage that you can see on the slide. Then we have to file at the Energy Ministry a letter of interest together with a form. The form is already uploaded in the webpage mentioned above. Then there's a payment of $100,000, which is a non-refundable registration fee. And if all of the above requirements are fulfilled, the ministry will issue a username and a password. They will grant access to the data room, which we know that it's a physical data room. They will provide the documents in an external hard drive for the companies to review, and additional information will be provided. Please note that even though there's no exact process in the guidelines, we do know that the ministry is granting access to a virtual data room, which it's it's obtained that access only by sending an email to the Energy Ministry, and they will grant a username and a password to grant access to this VDR, which contains a small amount of information, but that cannot be downloaded nor cannot be printed, but it's a good starting point. Who are the type of participants that can register? First, operators. The operators in this case are considered the companies that have paid the $100,000 registration fee, and what they called adherent companies. They don't pay the $100,000 registration fee, and they must only comply with legal and financial requirements. These adherent companies are companies that are gonna be part of a consortium, and that's why there's no requirements. They shall not comply with the requirements of technical capacities that I will explain in other slides. As I mentioned, there are two processes. The first, the registration, which I already explained, the $100,000 and the access to the web page. And after that is the qualification process, in which the company shall evidence the technical, financial, legal, and environmental conditions of requirements of the company. For the qualification process, after we have paid the $100,000 registration fee, and after we have submitted the documents, the initial documents required, the ministry will grant us access to a web page where we will need to electronically upload the documents, the technical, financial, legal, and environmental qualification documents that I will explain later. It is worth noting that these documents must be translated to Spanish if they come from another country where Spanish is not spoken. They shall be notarized and apostilled. If the company is awarded a block, the original documents must be submitted to the ministry before the contract is executed. This is important to clarify that only if the company is awarded the block, then we should file the original documents to the ministry. Before that, it's only needed to upload the documents. What are the legal requirements for the qualification process? There are 5 legal requirements, and these are requirements that specifically need to be complied with. The first is an affidavit, which form is already part of the bidding guidelines, in which the companies have to declare that there are no legal restrictions for this company to participate in the Intracampos bidding round. The second requirement is the power of attorney granted to someone in Ecuador. It can be an Ecuadorian or a foreign with residence in Ecuador, which will be responsible for submitting the registration, qualification, and if that's the case, the tender. Third requirement is a good standing certificate from the competent authority where the company is incorporated. The fourth requirement is a corporate or capital structure certificate evidencing up to the last shareholder that is a natural person, or a certificate that the company is listed in the stock exchange. This is a very peculiar requirement from Ecuadorian law and from this qualification process, in which the companies must disclose the last shareholder in their corporate structure. And finally, just an address in Ecuador in which the company will receive notifications. After the legal requirements, we shall comply with the technical capacity, with the technical requirements. And in this case, the bidding guidelines provide that the company shall evidence at least one of the followings. One, that the company is operating one or more producing petroleum blocks since 2017, and that at least in one of the years between 2012 and 2017, it has operated a production of 2,000 barrels of crude oil per day, or has drilled as operator 2 exploratory wells as defined in the regulations of hydrocarbons operations in any year during 2012 and 2017, or operated oil fields with reserves of at least 5 million barrels, 1P or 2P. How can the companies evidence that they have complied with these conditions? With the following documents. The bidding guidelines expressly accept contracts, concessions, licenses, 10K documents, 20F, Canadian Stock Exchange, or similar documents that may evidence the aforementioned. It is important to know that these documents, as I said earlier, may be evidenced by the parent companies. And this may be international operations or operations that the contractors have anywhere in the world. Which are the financial requirements required for qualification? For operators, that the minimum net equity that the government requires is $20 million. For adherent companies, which are going to be part of consortiums, the net equity is at least $10 million. And the companies must evidence the equity requirements with financial statements audited by third parties, stock exchange certificates, or audited information of their parent companies. It's important to note that the bidding guidelines provide that even though the minimum net equity for operators is $20 million, those $20 million will allow the company to offer tenders for up to 3 blocks. If the company has a net equity between $60 million and $120 million, they will be able to offer tender up to 6 blocks, and if that's the case, be awarded up to 6 blocks. And if the company has $120 million or more, it will be available to offer tender for up to 8 blocks, and if that's the case, be awarded up to 8 blocks, which is the total amount of Intracampos being offered in this round. The environmental requirements, government accepts certificates ISO 14001 or OSHA 18001. If these certificates are not available, the government also accepts EHS policies certified by a specialized international company, and these certificates shall be implemented during the last 3 years. In regard to consortiums, the consortium's public deed, the consortium agreement public deed, shall be filed at least 7 days before submitting the tender. The last date to submit the tender is January 18. That means that on January 11 will be the last day to submit the consortium agreement. This consortium agreement, it's a form provided in the bidding guidelines, and it's available online. It is a simple format in which the parties just agree to file a tender together. The operator will be the legal representative before the state. If a consortium is formed by 2 or more companies, they should sign and execute a JOA in which the operator must be legally designed. And finally, the operator must have at least 40% participation in the block in order to be considered an operator. Finally, this is the schedule that has been provided by the government in the Intracampos website. The bidding guidelines establish that this schedule may change during the course of the tender process. It has not changed since it was first published in September. We will be monitoring this, and we hope it doesn't change. But the main dates that we want to point out is the qualification and registration deadline, which is November 30th. That means that by November 30th, the companies must pay the $100,000 registration fee and upload all the documents required as part of the qualification process. After that, The next most important date is January, that I want to point out, it's January 18, where the offers must be filed and they will be open in a public hearing in which everyone has the right to review all the offers made. And finally, the execution of the contracts that is expected to be between February 13th and March the 15th. Now for the analysis of the taxes in the production sharing contract, I'm gonna provide a presentation to my colleague María Rosa Guerra once again. Thank you.
Okay, so we will review with you the taxes that will be subject for the production sharing contract. Basically, the legal framework regarding taxes will be this contract will be subject to the internal tax regime law, to the regulation to the internal tax regime law, the regulation issued by the Hydrocarbon Regulatory Agency, which is the an accounting regulation that takes regarding the investments, income, costs, and expenses during the term of the production sharing contract for exploration and exploitation of hydrocarbons, the contract itself, and the generally accepted accounting principles in the hydrocarbon industry. Regarding the taxes that will be subject to this production sharing contract, we have the income tax that it could be of 25% or 28%. The 28% depends on information that it should be provided by the company to the tax authority regarding the last beneficial owner or the ultimate beneficial owner. Then we have the advanced income tax, which it has to be calculated based on the 50% of the income tax of the previous year, less the income tax withheld during that year. The amortization of the investment will be for tax purposes for the exploration period in 5 years, and for the exploitation period, which means development and production, are under units of production. On the interest deductibility, it will not be allowed in the exploration and development period. It's not correct, the exploitation is development. And the other point that it's important is that the funds or the loans should be from third party and not from related parties. On the capital gains tax, there's a limit of up to 10% in transfers over 320,000. Then there's another limit that we should be considering, is that there's a 5% limit of indirect charges allocated by related parties from abroad. Under this limit for this specific contract, it should be considered the technical and administrative charges that we should be receiving from related parties. Regarding the value-added tax, we have here in Ecuador, the percentage is the 12%. There is also no possibility to have a tax credit on VAT, meaning that all the VAT that you will be paying should be part of the CAPEX and OPEX. And also there's the VAT that you should be paying on imported services. The other concepts that are important is the labor profit sharing, which in Ecuador is the 15%. But this 15%, it's allocated 12% that it has to be paid to the state and 3% to the employees. Tax withholdings that you have a range between 1 and 10% depending on the type of payment you should be doing. If you pay services to abroad, you will be subject to a 25%, and if it's on tax havens, it will be a 35%. Superintendency of companies, it has to be paid up to 0.1% of total assets. Special taxes like the currency remittance tax, that is a 5%. The municipality tax on total assets, which is 1.5 per 1,000. And the annual municipality patent tax, which will go up to $25,000. Regarding the import duties, we recommend to make a clarification with the Ministry of Hydrocarbons, since there's no clarity between what is stated in the hydrocarbons law in Article 87 on the importations of duties and what is being stated in the law. We also have other taxes and surcharges that we should be looking with. One will be the tax for sustained development of the Amazon region, which is a 4% of the sales price of each barrel. And this amount could not be never less than $2 per barrel. The royalties and surface fees, which is not applicable. We have the contribution for the development of education and scholarship, where it should be paid the $100,000 year during the expiration period. The substitute income for the provinces of Napo, Esmeraldas, and Sucumbíos, what is called Law 40, which is 0.05 per each barrel transported through the Trans-Ecuadorian pipeline. That this is additional to the transportation fee. The contribution for use of water and natural materials, that it has to be paid $24,000 in the exploration period and $60,000 in the exploitation period. An additional charge is for the transfer of rights, and it depends on which period it may be the contract. If it's in the exploration, it will be $5,000 per each 1% payable by the assignor, and in exploitation, the assignor must pay 1 per 1,000 of the net profits per each 1% transferred, not less than 5,000 per each 1%. Assignee has to pay 5,000 per each 1% transferred. Okay, so this will be the part for the taxes, and then we will open for questions.
We want to thank everyone for attending this webinar. We hope it provided some clarity on the Intracampos round, and we are hoping that this is a new beginning for Ecuador's oil and gas industry. We know that there are going to be upcoming additional bidding rounds, and we will be happy to assist in those cases as well. Once again, thank you everyone for attending. If you have any questions, that's our, you have on the screen our website where you will find our contact information. We will be happy to answer personally any questions you may have. Thank you once again, and hope to hear from all of you soon. Thanks.
Thanks.